Actus non facit trium nisi mensitria. An act does not make a person guilty unless there is a guilty mind. R versus Prince. The accused took away a girl believing that she was above 18 years of age. In reality, she was below 16 years, and taking her away from lawful guardianship was an offense. The court held the accused liable even though he believed the girl was major. Ignorantia juris non excusat. Ignorance of law is not an excuse. State of Maharashtra versus Mayor Hans George. Mayor Hans George was traveling from Zurich to Manila via Bombay, carrying a large quantity of gold with him. During transit, the Indian government had issued a notification under the Foreign Exchange Regulation Act restricting the bringing of gold into India without permission. The accused argued that he had no knowledge of the new notification. The Supreme Court of India held that once a law or notification is officially published, every person is presumed to know it. Mayor Hans George was held liable. RD alteram partem. Here the other side. No person should be condemned unheard. Maneka Gandhi versus Union of India. The passport of Maneka Gandhi was impounded by the government without giving her an opportunity to be heard. The Supreme Court held that principles of natural justice are part of Article 21. A person must be given a fair opportunity of hearing before adverse action is taken. Nemo judex in causa sua. No one should be a judge in his own cause. A.K. Kripak versus Union of India. A member of a selection board was himself a candidate for selection to the Indian Forest Service. The Supreme Court held that participation of the candidate in the selection board violated principles of natural justice because of bias. UB just IB remedium. Where there is a right, there is a remedy. Bhim Singh versus State of Jammu and Kashmir. Bhim Singh, a member of the Jammu and Kashmir Legislative Assembly, was travelling to attend an assembly session. Police officers illegally arrested and detained him to prevent him from attending the assembly meeting. He was not produced before a magistrate within the prescribed time. The Supreme Court held that the arrest and detention were unlawful and violated Bhim Singh's fundamental rights under Article 21 and 22. The court awarded monetary compensation to him for violation of his legal and constitutional rights. Volenti non fit injuria. To a willing person, no injury is done. Hall versus Brooklands Auto Racing Club. A spectator watching a motor race was injured when a racing car went out of control. The court held that spectators voluntarily accept risks naturally connected with the sport. Hence, the defendant was not liable. Res ipsa loquitur. The thing speaks for itself. Berne versus Burdle. A barrel of flour fell from the defendant's warehouse and injured the plaintiff standing outside. The court held that such accidents do not ordinarily happen without negligence. Therefore, negligence was presumed. Qui facit per alium facit per se. He who acts through another acts himself. State Bank of India versus Shyama Devi. A bank employee fraudulently misappropriated money deposited by a customer. The Supreme Court discussed employer liability for acts of employees and explained the principle of vicarious liability. Damnum sine injuria. Damage without legal injury. Gloucester Grammar School case. A teacher opened a rival school, causing a financial loss to another schoolmaster. The court held that mere loss without violation of legal right is not actionable. Injuria sine damno. Legal injury without actual damage. Ashby versus White. The plaintiff was denied his legal right to vote, though the candidate he supported still won. The court held that violation of a legal right itself gives rise to a cause of action even without actual loss.